In 1886, the Supreme Court decided a case about fences. It never ruled that corporations count as people under the Constitution. But a court clerk wrote a line into the case summary claiming the court had already agreed they did. That line wasn't part of the ruling. It wasn't law. Nobody voted on it. More than a century of corporate constitutional rights trace back to that one sentence. By the end of this video, you'll know exactly who wrote it, why he wrote it, and why nobody stopped him. California, 1878. The state rewrote its constitution. One new rule specifically targeted railroads. Unlike an individual property owner, a railroad corporation couldn't deduct its mortgage debt when the state calculated its property taxes. Southern Pacific Railroad refused to pay. The dispute that actually reached the Supreme Court in 1886 came down to something almost absurdly narrow. Were the fences along the railroad's right-of-way part of the roadway, which the state taxed, or a separate improvement which the county was supposed to tax instead? The court ruled the fences didn't belong in the state's assessment. The tax bill lumped the fence value in with everything else. Nobody could separate out how much came from the fences alone. So the whole assessment got thrown out. The amount actually in dispute, $13,366.53. One county's tax bill for 1 year. This wasn't the first time someone tried to argue corporations deserved constitutional personhood. 4 years before Santa Clara, in 1882, a former U.S. Senator named Roscoe Conkling stood before the Supreme Court in a related railroad tax case. Conkling had actually helped write the 14th Amendment in 1866. Now he told the court the drafting committee had secretly meant to cover corporations all along. He backed it up with what he presented as the committee's own private journal. A historian who examined the claim decades later called it a deliberate, brazen forgery. That case never got a ruling on the merits. It was dismissed as moot. But the argument was already in the air. Corporations deserve the same constitutional protection as people. It just needed a case that would stick. Here's the moment the whole story turns on. Pay attention to exactly when this happens. January 1886. Before oral argument even began in Santa Clara County versus Southern Pacific Railroad, Chief Justice Morrison Waite spoke to the lawyers in the room. Here's exactly what he said. The court does not wish to hear argument on the question whether the provision in the 14th Amendment to the Constitution, which forbids a state to deny to any person within its jurisdiction the equal protection of the laws, applies to these corporations. We are all of the opinion that it does. Say that again slowly. Before argument started, not a ruling, a comment. Justice John Marshall Harlan wrote the court's actual opinion, unanimous, and it never goes near the 14th Amendment question at all. The whole decision rests on the fences. Improperly assessed, improperly bundled, assessment void. That's the entire holding. Waite's comment about corporations being persons never made it into the written law of the case. The court simply never decided that question. Not that day. Not in that opinion. So how does a comment that isn't part of a ruling end up shaping a century of law? Here's the answer, and it comes down to one person. It happens through the headnote. That's the short summary, printed right before a case in the official reports. Written not by the justices, but by the court's reporter of decisions. In 1886, that job belonged to a man named J.C. Bancroft Davis. Before his government career, Davis had been president of a railroad company himself. Before publishing, Davis wrote to Waite to confirm he'd gotten the quote right. Waite wrote back, "I think your memorandum in the California railroad tax cases expresses with sufficient accuracy what was said before the argument began. I leave it with you to determine whether anything need be said about it in the report, inasmuch as we avoided meeting the constitutional question in the decision." Waite didn't order it published. He also didn't stop it. He handed Davis the choice and told him plainly the court had dodged the real question. Davis published it anyway. In 1906, the Supreme Court finally ruled directly on what a headnote actually is, their answer, not the work of the court. Just the reporter's own understanding, written for convenience. No legal force at all. That's the exact kind of document that had already been shaping corporate law for 20 years. 2 years after Santa Clara in 1888, a different case, Pembina Consolidated Silver Mining versus Pennsylvania, cited the Santa Clara headnote as if it were a real, settled ruling. It used that to hold, for the first time, that corporations really were persons under the 14th Amendment. The dictum became precedent. From there it kept going. Justice William O. Douglas later called Santa Clara one of the most momentous of all our decisions. In 1938, Justice Hugo Black dissented sharply, writing that the 14th Amendment was meant to protect weak and helpless human beings, not pull corporations out from under state regulation. Decades later, legal historians trace a direct line from Santa Clara through corporate spending rights all the way to Citizens United. Here's the honest complication. Historians still argue about how much this one case actually mattered. Some say Santa Clara got too much credit. The real legal shift, they argue, happened decades later, through separate cases and a broader legal strategy, not one clerk's choice in 1886. The story isn't as tidy as one sentence changed everything. But the core of it isn't in dispute. A Supreme Court case that never decided whether corporations are constitutional persons became the foundation people built that exact idea on top of. A former railroad executive, given the choice, decided a sentence nobody voted on was worth writing into the official record. If you want the next hidden clause behind the laws that shape this country, subscribe. There's a lot more where this came from.